Vibbert versus Parr Incorporated is a Texas case we discussed earlier, and it is a good case for more than one reason. First, it illustrates judicial precedent, and that's why we used it in the first video. Second, it illustrates how badly liens can be messed up. Third, it is useful for illustrating the concept of consideration. And finally, it stands for the proposition that a certificate of title is not bulletproof. Let's look at the case in a little more detail. The case was decided by the 8th Court of Appeals, which is located in El Paso, in 2006. Years earlier, Sandra and Joseph Vibbert bought a Nissan Altima. They probably borrowed money to buy it. I say probably because the only thing I really know for sure is that when the Vibberts traded in the Altima in 2001, the Vibberts still owed $9,367.95 to a bank named Norwest. Let's assume they borrowed money and talk about how that would work. Norwest Bank loaned them the money, and Norwest Bank most likely had them sign papers which spelled out the following. 1. How much money the Vibberts were borrowing. 2. The interest rate the Vibberts would be charged. 3. The monthly payments would be. What the monthly payments would be. 4. If a payment is missed, the entire loan suddenly becomes due immediately. A smart lender bank would also have spelled out what happens if a payment is early or if a payment is too much, but it's more common for payments to be late and too small. And a smart lender bank will have what is called an acceleration clause. An acceleration clause says that if a payment is late or if a payment is too small, then all of the money comes due at once. An acceleration clause permits a lender to take action as soon as there is any sign that the money will not be paid. An acceleration clause means the lender does not have to wait until all the payments are missed or short. A common car loan is for 36 months. If a borrower misses the payment on month number 1 and 2 and so forth, and if there is no acceleration clause, that means if there is no acceleration clause, then the lender must wait until the 36th month to try to do anything like sue. Back to our list. Number 5, that Norwest has a lien on the car for the amount due on the loan. The creation of a lien must be in writing and must be clear. It creates a property right which belongs to Norwest. Norwest essentially owns a part of the car. 6, that only Norwest can sign away the lien, and Norwest will not sign away the lien until the Vibberts pay all the money the Vibberts owe. At which point, of course, Norwest is supposed to release the lien, and that's something they promise to do, is release the lien once all the money is paid. The part about only Norwest can sign away the lien and will not sign away the lien until all the money is paid, that is pretty much the law. And so you wouldn't think it'd have to be in a contract, but a smart lender bank will put it in writing just to be safe. 7. If the car is ever sold or used for another loan, the Norwest lien is superior. It is also the law that the first lien is superior to liens that come later, but a smart lender will put it in writing just to be safe. 8. That Norwest will hold the certificate of title. That prevents a lot of problems and misunderstandings, usually. And 9. If the Vibberts default on the loan, Norwest can take possession of the car without going to court first. Without that kind of provision in the agreement, Norwest might get accused of stealing if the bank ever repos a car. In situations like this, it is helpful to draw a diagram showing the consideration that is exchanged by each party. In the diagram I've drawn here, there are basically 3 parties involved: Vibberts, the Nissan dealer, and Norwest. Between Vibberts and the Nissan dealer, the Vibberts give the Nissan dealer a down payment. That's typical. I'm just imagining they did it in this case. And then the Nissan dealer gives the Vibberts ownership of the car and possession of the car. I've drawn 2 separate lines for ownership and possession because they're not necessarily the same thing. For example, when somebody leases a car, they get possession of the car, but they don't get ownership. Then between Nissan and Norwest, I've drawn a line showing all the money goes from Norwest to the Nissan dealer for the car, and then the Nissan dealer sends the certificate of title to Norwest. And finally, between Norwest and the Vibberts, I've drawn a line from the Vibberts to Norwest showing the Vibberts give a lien to Norwest and the Vibberts give the right to repossess the car to Norwest. Also, the Vibberts give Norwest their promise to repay the money that they borrowed to buy the car. Norwest gives the Vibberts a promise to release the lien when all the money is paid. Norwest would probably actually receive the certificate of title from the Department of Motor Vehicles, but I'm trying to keep things simple. Also, if you don't know, the certificate of title should say that the Vibberts are the owners of the Nissan and that Norwest has a lien. Now, on with our story. In 2001, Sandra and Joseph Vibbert traded in the Nissan for a Mercedes. The car dealership that took the trade-in was GS Motorsports Incorporated, and GS promised to pay off what was owed on the Nissan, which was supposedly $9,367.95. I do not know if the promise was in writing or not. I suspect that it was not in writing, but it appears to have been a real promise. Here is a diagram of the deal between the Vibberts and GS Motorsports. This is kind of a four-way deal, with Norwest being one of the parties involved, except you'll see that Norwest was really kind of cut out. Here's how that worked. The other three parties are the Vibberts, GS Motorsports Incorporated, and a bank. And I have reason to believe there was another bank involved here that financed the purchase of the Mercedes. It's not discussed in the case to any great degree, but from what I can read, the Vibberts gave GS Motorsports a down payment, which in my mind means they borrowed money from somebody somewhere to pay for the rest of the Mercedes other than the trade-in. So I put in bank. So what you've got is the typical three-way agreement when anybody buys a car, except you've got Norwest off to the side. And the three-way agreement between the Vibberts, the bank, and GS Motorsports is just like almost just like it was before between the Vibberts and the Nissan dealer when they first bought that Nissan, and Norwest when they first bought the Nissan. I'll go through this very briefly. Between the bank and GS Motorsports, it's quite obvious. The bank gives GS Motorsports some money, and GS Motorsports sends the certificate of title to the Mercedes, not the Nissan, but the Mercedes, to the bank, because the new bank that I don't know the name of is financing the Mercedes. The Vibberts give the new bank a lien on the Mercedes. They give the new bank a promise to repay the bank for the money they've borrowed, and the bank gives the Vibberts a promise to release the lien once they've been paid. The really complicated or new part is between Vibberts and GS Motorsports. The Vibberts give GS Motorsports ownership of the Nissan and possession of the Nissan. GS Motorsports gives ownership of the Mercedes to the Vibberts and possession of the Mercedes to the Vibberts. And GS Motorsports, and this is key, I put it in a different shade, I hope it shows up good. GS Motorsports gives the Vibberts a promise to pay Norwest. But as you can see from the diagram, nothing ever actually went to Norwest. Now, a key question for the Vibberts would be, what was the consideration for the contract for the Mercedes? Did consideration include the promise to pay Norwest or not? In the diagram, I've done it so it is included. The promise to pay probably was part of the consideration for the purchase of the Mercedes. That is, the promise to pay Norwest probably was part of the consideration for the purchase of the Mercedes, so I included it in the diagram. I believe the promise to pay Norwest was part of the deal with GS for two reasons. One, GS later said it sent Norwest a check, but apparently the check bounced or something. Two, it's not a real trade-in if the Vibberts still have to pay off Norwest. I mean, quite obviously they intended GS Motorsports to get the Nissan, both ownership and possession of the Nissan. Why would they give up the car if they had no intention for Norwest to get paid? And they claimed certainly later that GS Motorsports promised they would pay Norwest. So I'm thinking it's part of the deal. It's not a separate deal. It's part of the whole package between GS Motorsports and the Vibberts. And so as you can probably tell later, and I think we've already discussed this in the first video, the Vibberts wind up suing GS Motorsports. The way it should have worked with the certificate of title is that GS paid off Norwest. Then an agent for Norwest signed the back of the certificate of title, and then Norwest sent the certificate of title to either GS Motorsports or the Vibberts. Then the Vibberts signed the back of the certificate. Either they get it themselves and sign it, or they go to GS Motorsports and sign it in the GS Motorsports office once GS Motorsports gets it. But anyway, either way it happens, Norwest sends the certificate to somebody so the Vibberts can also sign the back of it. And then somebody took the certificate, this is the way it should have worked, took the certificate to the Texas Department of Motor Vehicles, which would then print a clean new certificate showing who was the new owner of the Nissan. But that did not happen. And ideally, GS Motorsports would clean up the certificate of title before reselling the Nissan. But a lot of car dealerships sell cars so fast that it's impossible to get a clean title or a new certificate of title before a car is resold. And in fact, only a few days later, GS sold the Nissan to a couple named Kuwamoto. Obviously, the Kuwamotos drove off in the Nissan without the certificate of title. Norwest was not paid off, and Norwest started after the Vibberts for the money. As far as I can tell, the bank was never paid, at least not up until the point lawsuits were filed. So eventually there was a bank, Norwest, and a loan company, Signet, that claimed they both needed the certificate of title to the Altima. Signet is the company that helped the Kuwamotos buy the Nissan. And Norwest was still hounding the Vibberts for the money. Why was Norwest hounding the Vibberts and not hounding GS Motorsports? The bank might have been hounding GS, I don't know, but they were definitely trying to get the Vibberts to pay because Norwest had a contract with the Vibberts. Norwest did not have a contract with GS Motorsports. I don't know what Signet did to try to get the title, except they eventually hired a company called PAR to fix the problem. Fix is my word. PAR appears to be in the business of fixing titles, either repossessing cars, replacing lost paperwork, that sort of thing. I'm not sure exactly. And I don't know if Signet tried to get the title from GS Motorsports or what GS told Signet. All I know is that eventually Signet hired PAR. Then somebody at PAR, or somebody working for PAR, came up with two documents, both of which might be forgeries. They certainly appear to be forgeries. I say might because that was never said for sure. One potentially forged document, you may recall, was a release of lien from Norwest. If it was genuine, the release would mean the bank is giving up its claim to the Nissan. But the bank had not been paid, so there was no reason for the bank to give up its claim. It's a long story, and I don't know all the details, but the short version is that the signature on the release said Brenda Bodkin as agent for the bank Norwest. But Brenda Bodkin, who's a real person, was asked about it, and she denied ever signing it. There's an interesting side note here that I did not mention in the first video. Brenda Bodkin was not an employee of Norwest. She worked for PAR, which also did work for Norwest. In this case, PAR was working for Signet, because PAR sometimes worked for Signet and sometimes worked for Norwest. PAR was an independent contracting company that worked for all banks that were willing to pay it. But in this case, PAR was working for Signet supposedly, but because PAR sometimes worked for Norwest, PAR had power of attorney for Norwest. I guess Norwest just gave PAR a blanket power of attorney to be used in all the cases that Norwest hires PAR to work for. But in this case, once again, PAR was not working for Norwest. PAR was supposed to be working for Signet. Nonetheless, it appears somebody at PAR thought they could do whatever they wanted to fix the situation because PAR worked for both Norwest and Signet. But the obvious problem was that nobody at Parr had actual authority to release the lien on the Nissan. This gets into questions of agency law, which we don't need to really completely talk about right now. Suffice it to say, sometimes Parr was an agent for Norwest, sometimes Parr was an agent for Signet, and in this case, Parr thought, well, what the heck, they would be the agent for both of them, even though it really was a conflict of interest. The other potentially forged document was an application for a new certificate of title. It showed it was signed by Sandra Vibbert, but Sandra Vibbert denied ever signing it. And no court ever determined who signed those documents. That's why I keep saying they might be forgeries. So the Vibberts still owed Norwest, but the Kuwamotos had the Nissan. So the Vibberts sued Parr. And they sued them for conversion, you may remember, which basically means Parr is being accused of stealing. Although conversion is not the same thing exactly as theft, it can be theft in some situations. The Vibberts had filed a lawsuit against GS Motorsports. It was a separate lawsuit, and I cannot tell whatever happened to it. Now, as you might remember, Parr had filed a motion for summary judgment, which is a legal way of bringing the lawsuit to an early end. Parr claimed there was absolutely no evidence that the Vibberts owned the car at the time of the alleged forgeries. The question for the court was whether or not the old certificate of title, the one which showed the Vibberts owned the Nissan, the one which Norwest Bank was holding on to, whether or not that old certificate of title was any evidence. If it was evidence, the Vibberts owned the Nissan up until court, because the certificate was never signed and released by Norwest, then it was evidence the Vibberts owned the Nissan at the time of the forgeries. In its decision, the El Paso Court of Appeals held the certificate of title was not evidence of ownership in this case. It might be in other cases, but not in this case, because the undisputed fact was that the Vibberts traded in the Nissan. The Vibberts intended to give up ownership. They intended to trade in for the Mercedes. The Vibberts drove off in the Mercedes, and they left the Nissan with GS Motorsports. The Vibberts cannot now say they retained ownership after all of that. So, one of the true victims in this case was Norwest, unless, of course, they got their money from the Vibberts at some point, but I never heard that they did, and I can't tell that they ever did. Norwest did everything it was supposed to do. Norwest got a lien, and Norwest held on to the certificate of title. Norwest should have been paid. It should have worked out for Norwest, but it didn't. The end.